Hey, Tony DeWitt here, Missouri Appellate Attorney. I'm retired, and this is not legal advice. Everything I say is simply commenting on the law. And this will be what we're commenting on today. Rhonda Jewell is in trial in Baker County, Florida, for the hot car death of the child she was babysitting for. Well, we already know how this one ends.
Ms. Jewell, would you and your attorneys please stand while the verdict is read? At this time, I'm going to ask the clerk to please publish the verdict.
In the Circuit Court of the 8th Judicial Circuit, in and for Baker County, Florida, State of Florida versus Rhonda Jewell, case number 02-2023 CF 333. We, the jury, find as follows as to count one of the information. The defendant is not guilty.
Now, that was the verdict that they wanted for the defense. They wanted the involuntary manslaughter verdict because it's a lower punishment than the felony murder charge, which is also there.
We, the jury, find as follows as to count two of the information. The defendant is guilty of third-degree felony murder as charged in the information. We, the jury, find as follows as to count three of the information. The defendant is guilty of leaving a child unattended or unsupervised in a motor vehicle causing great bodily injury as charged in the information. So say we, this 8th day of November 2024, at McClenny, Baker County, Florida, signed by the four-person David Saints.
Very good. Be seated, please.
Defending the indefensible is a very difficult task, and oftentimes it boils down to just humanizing the defendant. Now, in a situation where there is a plausible other person involved, as in Casey Anthony's case, it was possible that somebody else had taken the child. In addition to setting that up, you also have to humanize the defendant, which I think the defense attorney did there. And then the other part of that is you point out the fact, as they did in Casey Anthony's case, that they proved she was a liar, not a murderer. In this case, there really isn't any room to do that. So there was never any mystery in this case. There was no whodunit here. There was really a whydunit here. And why was the important question. In spite of that, it appears that the jury wasn't as focused on the why as on the relationship between the parties. At one point during the trial, the jury specifically requested a readback of some of the cross-examination of the mother of the child.
On the days that Rhonda had Araya and she was not keeping Stacy's children, you had no objection to her running errands with her or taking her to other places, correct? Answer, correct. Question, when you asked Rhonda to be a caregiver for Araya, you were familiar with the care that she had given to other children in this capacity. So I'm assuming you felt like she knew what, by Mr. Yazdia, objection, Your Honor, by the court basis for that is what, and there's a sidebar here. Give me one moment. Okay. And continuing on by Ms. Johnson, question. Ms. Page, I was simply asking because you were aware of Ms. Jewell being a nanny to other children. You knew that she knew what you were expecting of her when you asked her to take care of Araya, correct? Answer, correct. Question. On this particular day, this was the earliest that Rhonda had ever picked up Araya from you. Is that correct? Answer, correct. Question, so she had to be there even earlier than usual? Answer, correct. Question, and then you said that you usually left your house at 1 to travel to Stacy's house to pick up Araya? Answer, correct. Question, and you did the same thing on this day on July 19th? Answer, correct.
It seems to me that the role of human memory was an important part of this case and its discussion. I forget things all the time. I sometimes get up and go into the other room and go, why in the world did I come in here? I think everybody does that. I think it happens to you more the older you get, but the fact is everybody does that. And human memory is not watching a VCR or a DVD. It isn't like you record it and then you can play it back in your head. Let's just say it's like having a faulty hard drive. You'll get part of the file, but not the whole file. If you have ever tried to come up with the lyrics to a song that you know, and you get to that part where it starts to go to the bridge about, for example, there's a bad moon on the rise, and you can't remember what the next line is after there's a bad moon on the rise, then you know that there are holes in your memory. There are always holes in all of our memory, yet we can often find a way to recover those holes later on. During the trial, the defense put on an expert witness, and I felt like he had some really good information for the jury.
Okay, sir, before you sit down, if you will raise your right hand and face the clerk, and she will administer the oath.
Do you solemnly swear or affirm that the testimony you give will be the truth and the whole truth, so help you God?
I do.
Have a seat, please, sir. I'll ask you to sit up close to the microphone, adjust it so that you can speak to it.
Okay, thank you.
And then I'm going to ask you to state your name and then spell your name for the record, please.
I'm Brian Cahill, Brian Cahill.
Thank you, sir. Counsel?
Good morning, Dr. Cahill.
Good morning.
Could you please give the jury a summary of your educational background?
Sure. So I earned my bachelor's degree in psychology at Illinois State University in 2005. I received a master's degree in experimental psychology from the University of Colorado Springs in 2008, and then a PhD in legal psychology from Florida International University in 2015.
What is your current profession, Cahill?
I'm an associate instructional professor at the University of Florida.
And how long have you been a professor?
I was hired there in 2016, and then before that I was an adjunct professor at the Florida International University for, I think, 3 or 4 years, something like that.
So how long have you been a professor?
About a decade now.
And what classes teach at the University of Florida currently?
So I regularly teach cognitive psychology, legal psychology, research methods. I've taught social psychology there, and introductory to psychology, and I teach sensory processes every once in a while as well.
Have you testified in court of law before?
I have. This, including today, is my 7th time, I believe.
And in what field do you consider your expertise?
So I'm a legal psychologist, which it's a fancy way of saying I'm a social cognitive psychologist that applies area of psychology to the legal system. Specifically, I study memory and decision making, particularly in a legal system avenue.
And speaking of memory, do people often hold false beliefs regarding memory?
Yes, they do.
Could you give the jury a couple of examples of false beliefs related to memory?
Sure. So 2 of those basic findings from memory research comes back to Ebbinghaus, who's the father of memory research, is the exposure time, which is the idea that the longer time you have to view thing, you'll remember more information. About 39% or something around there get that question wrong. And then forgetting curve is another one. So forgetting curve is the idea that what we find is that you forget most of the information of an event, or not, but a lot of it right after the event, and it slowly tapers off. So after a while, what gets into your memory is generally there for a while, but we do forget a lot quite quickly after the event. And about 35% or somewhere around there, people get that idea wrong well.
So when you say people are getting that idea wrong, is it to say that people believe that you remember more than you actually do after an event?
I'd say yes. So, and I'm talking about people who don't study this living, right? Laypersons. Related to that is another finding that laypersons typically believe that memory works like a DVD recorder, that we can record everything that we encounter, and then we store it as is, and we can just recall it later on. If you've seen the movie Inside Out, it kind of represents that when they bring orb, in the brain with joy and whatnot. That's not how memory works. Memory is more like a Wikipedia page where you can edit your own memories, and so can I. So It's not as accurate as some people believe it to be.
Defense then tried to put on another expert witness, and this witness had been previously excluded at trial. And as a result of that, in order to make a record for appeal, the defense did his testimony and had it committed to the trial record, and he did it outside the hearing of the jury. After he had gotten his testimony finished, the defense attorney asked the judge to reconsider his ruling.
Judge, at this point, I've asked the court to reconsider its decision not to allow Dr. Diamond to testify in this case. We'd ask the court to.
Well, does the state first wish to make any inquiry of the doctor?
Judge, I'll ask a few inquiries.
You want to get
So the judge, wisely, I think, asked the prosecution, hey, prosecution, what do you think about that?
On your PowerPoint slide, if we can go to the first page. The title there, can you just read the title of your PowerPoint presentation?
Neuropsychological perspective of how it is possible to forget a child in a car in relation to state of Florida versus Rhonda Jewell.
And it's safe to say that the title of your presentation is the bulk of the sum and substance of what you were testifying to. Is that fair to say?
That's correct.
Okay. If we can go to the last slide. And it would be your intention to testify to the items that are in your slide and present them to the jury?
Well, as a scientist, I like to summarize my work. My intention would only be what would be permitted in the court.
Fair. Can you go ahead and read the last paragraph on the last page?
Like other loving and attentive parents and caretakers, Rhonda Jewell unintentionally and unknowingly lost awareness of Araya in her car.
And it's fair to say that that would be potentially within the scope of your testimony today at trial. Is that fair to say?
That's correct.
In preparation for today, are you at all familiar with Dr. Cahill's testimony in this case?
I was not here while he gave testimony.
Were you, did you get a copy of his prior deposition?
Yes, I did.
And are you familiar with that deposition?
Yes, I am.
Okay. And same thing with this hearing. Are you familiar with what he testified to in general at his hearing?
I received one document, which may very well have been his hearing.
Which may have been a transcript from the hearing?
Yes.
Okay. Are you familiar that he testified? Okay, I thought Your Honor said something plausible. To me means that I cannot say with any confidence whether or not leaving Araya Page in the car was because of prospective memory error. Are you aware that that's his testimony?
Yes.
Okay. And do you agree with that testimony?
Well, as a scientist, one has to be open to any possibility, no matter how unlikely.
Okay. So if I asked you to whether or not you disagree with that statement, what would your response be?
Based on my interview with Rhonda Jewell and what I read about her from other depositions, I would disagree with him that she committed this act intentionally.
Sit, Judge.
We renew our request, Judge.
I've heard your argument. Any argument?
Just we rely on all of our prior motions, argument, everything else we raised, and now it's duplicative.
Okay, well, with due respect to Dr. Diamond, I'm going to continue to exclude his testimony for the reasons that were set forth in the written order that was entered sometime back in September, and for the further reason that the court has allowed the testimony of Dr. Cahill, who also is an expert in the field of prospective memory. So,
Judge, I'd just like to perfect the record a few more minutes if I can. I'd like to perfect the record a few more minutes with some more testimony, just for the record.
what I don't see any need for it, but if you want to do it, yeah.
Whether the court made the right decision is going to be an important part of any appeal in this case, assuming an appeal gets filed. The crux of the matter was that they wanted to have, the defense wanted an involuntary manslaughter verdict, and the state wanted a third-degree felony murder verdict, and the state got what it wanted. As a result of that, there could very easily be an appeal on the issue of whether that expert witness should have been excluded. It didn't sound to me like the expert witness had been excluded on the basis of anything wrong with his academic record or his research methods or anything like that, any of the traditional Daubert areas. The judge additionally excluded him basically because his testimony was repetitive of the other expert. But a sympathetic appellate court might very well take a hard look at that, given the fact that he testified differently than the other expert did, and he testified directly opposite of the state's expert in the case. So that, in some ways, makes it a bit more of an appellate issue going forward. There is a pretty good chance that this lady is probably going to spend at least 15 years in Florida State Prison. And I'm sure that is not what she wants to do. But the magnitude of the loss here was pretty significant. Anytime you lose a child, it is a horrible loss, and it is devastating to you. And it can often cause problems in the marital relationship. Divorces are a frequent side effect of having the loss of a child in a marital relationship. And that's because people tend to place blame as opposed to fix problems. And it's always easier to assume that the other person is to blame than to affix any of that blame to yourself. And as a result, like I said, a lot of times divorces happen. In this particular case, the family seems to have stayed together, but clearly it has put a huge stress on their marriage. I feel badly for the woman who forgot the baby was in the car, but you know, I have forgotten a lot of things in my life, but I've never forgotten and left somebody in my car. And Florida now has a law that says, you know, if you leave a child in a car, even for a short period of time, that they will break your window and take the child out, and they will probably charge you with child neglect. And I think that is a good thing. There is no more of this running into the store to get a loaf of bread and leaving the car running with the kid inside and the air conditioner going, at least in Florida. Because, as in this case, the inside of a car in summer in Florida can reach above 133 degrees, which is not survivable in the long term for someone trapped inside that vehicle. And what may seem like only a couple of minutes inside the store can sometimes stretch to 10 or 15 minutes. And if the air conditioner were for any reason to quit running or you run out of gas or whatever, a child could die in that period of time, or at least suffer significant brain injury. So this, I think, is a good verdict. I think it was an appropriate prosecution, and I believe quite strongly that justice was done here. I'd love to hear your thoughts. Drop them in the comments down below. Like, share, subscribe. You can reach me at the email address above, and if you have the opportunity today, do a kindness for someone. And then come on back down here and join me at the beach tomorrow. We'll talk about something else. I shouldn't have to say this, but you don't seek legal advice from a guy down at the beach. You seek it from a lawyer in a lawyer's office, where there are people running around in suits and secretaries and all kinds of other people. I'm just a YouTuber. I'm a retired attorney at this point, and although I retain my license to practice in the state of Missouri, I am not here dispensing legal advice. I'm just offering general content on the law. And here are some videos that YouTube thinks you may enjoy.